Hello friends, this is a dictation which was dictated in 2019 of a senior PA examination of Delhi High Court. So be ready for the dictation. 5 seconds to go. A perusal of entire evidence would show that the appellant has not denied his presence at the spot. The stand taken by the appellant is that he was working in one of the nearby traveling agency office as an employee, and since the owner of the traveling agency had not paid regular monthly to the police falsely implicated him. The facts stand proved by testimony of witnesses regarding apprehension of the appellant from the spot and recovery of the contraband. The appellant has only disputed that this recovery was not made from him but was made from someone else, and he was falsely implicated. There is no doubt that the place from where the appellant was apprehended was a busy place. However, it is not necessary that if there are persons around, they would be ready and willing to join the investigation on the request of the police. It has come in the testimony of police officials that request was made to public persons to join the investigation, but they refused to join. I consider that on the ground that no public witness was ready to associate the case of the prosecution cannot be doubted. It is settled position that the testimony of police official cannot be rejected on the ground that the police official was the sole witness of recovery of contraband, and the public witness who was examined turned hostile. In a number of judgments, the Supreme Court observed that the conviction can be based on the sole testimony of an inspector if the other circumstances existed which corroborate the testimony. As far as non-association of public witnesses at the time of recovery is concerned, I consider that this is not sufficient to throw out the case of the prosecution. It is very hard these days to get association of public witnesses in criminal investigation. Investigation itself is a tedious process, and public witness who is associated has to spend hours at the spot. Normally, nobody from public is prepared to suffer any inconvenience for the sake of society. The other reason for the public witness not readily agreeing to associate with investigation is harassment of public witness that takes place in the courts. Generally, a public witness should be called once to depose in the court, and his testimony should be recorded and he should be discharged. But experience shows that adjournments are given even in criminal cases on all excuses, and if adjournments are not given, it is considered as a breach of the right of hearing of the accused. These adjournments are specifically taken by counsels for accused persons when witnesses are present, just to see that witnesses get harassed by calling them time and again. This attitude of the courts of sending witness back is a major cause of harassment which discourages public from associating in the investigation of any case. Since the police is faced with this handicap, the police cannot be blamed for not associating public witnesses. There is no presumption that the police witnesses are not credible witnesses. The testimony of every witness whether public or police, has to be judged at its own merits, and the court can believe or disbelieve a police witness considering the value of his testimony given the facts and circumstances of each case.